Hi, I'm Danny Queen. Welcome to another exciting edition of Color Me Poetry this evening. And this evening we'd like to talk about law. We'd like to talk about copyright law and how that relates to authors and authors in general, really. And so many people call me and write me and ask about copyright. So I decided to do a show on copyright and copyright law. So I'd like to take this time to introduce my most illustrious guest in the person of Ms.Theo Brown. She's an attorney at law, and we're glad to have you here this evening.
Thank you. I'm happy to be here.
How'd you first get started in copyright law? I know you have a history of different type of law, but why copyright law?
Why? I've always been interested in creativity, and I don't think that I've discovered any latent talents that I have of my own. So the next best thing for me was to represent people who are creative, and I just really get a charge out of people being creative, writing poems and writing music and things of that sort. And about 12 years ago, after practicing law for about 2 years, I was blessed to have an opportunity to work on a project that involved copyright law, and ever since then I've been hooked, and I've been again practicing in this area for about 12 years now.
So you kind of stumbled into it?
You don't stumble. I believe you don't stumble. I think that it's all divinely ordered, and at the time I was really open and receptive to it, so again it happened that way.
Well, with copyright law, there's so many people who write me and call me and ask about so many things about copyright.
Right.
There are a lot of authors, a lot of poets, I guess authors in general, who want to know about copyright, where to get it done, and the duration of it, and those kind of questions. What kind of questions do you get from people?
Oh, I get a lot of questions, and what I'd like to start off by saying, or at least making a distinction between the various areas of what I call intellectual property. It's a branch of law. It's called intellectual property, and the three components to it. You have copyright law, you have trademark law, and then you have patent law. Right. And each of those branches covers a different type of intellectual property. Intellectual property being the property of the mind, your creative mind. Copyright protects works of visual arts, graphic productions. It protects pantomimes and choreographed works, and trademarks protects titles and slogans and designs, and then patents protects inventions. And so you have to be real clear just what area that you're dealing with. But with respect to authors, people who are prolific writers, literary works, then that's what you deal with when you talk about copyright protection.
Okay, you deal with all three.
Actually, I deal with two. I deal with trademark and copyright. Patents is a specialty in itself, in that you have to have a special license to be a patent lawyer. And although I don't practice in that area, I do have colleagues that do. And to the extent that I can't help a client, then I would refer those prospective clients to my colleagues.
What is the difference, say, between the title of my book, A Wake Up Call, and maybe a trademark?
Well, again, you could possibly get protection for your title via trademark law, is what you could do. And there's a whole application process that you go through with trademark as you do with copyright and patents. The other important distinction to make in these three areas of intellectual property law is that they're administered by different government agencies. Okay. Copyright law is administered by the Library of Congress, which, as we know, is a branch of the U.S. Congress, and the office is located on First and Independence Avenue Southeast. The trademark law, you got it, that's right, 401. Right. The trademark law and the patent law are administered by the U.S. Patent and Trademark Office, which is located in Crystal City, Virginia, and it also is an arm of the administrative branch of government. That is, the president appoints the commissioners of patents and trademarks.
So all three of these divisions come under what?
It's called intellectual property versus real property or personal property. It's called intellectual property, property of your mind.
Because I know, I think it was last year, Dr. Martin Luther King's estate was in litigation with one of the universities about his intellectual property. Right. And they wanted to know, they were trying to find out, well, who owns the copyright?
That's right. Speeches, again, that's a form of literary work, and you're entitled to protection for your speeches. The question becomes, what happens when you give a speech in a public forum? Are you giving up your rights to protection? And so, if to the extent that you actually have you've written your speech and you've passed out the speech in this public forum, then you can conceivably protect the speech in that respect. or if you're recording the speech simultaneous with the giving of the speech, then there's protection there as well. So you just have to be very careful in terms of what information you're willing to divulge or to disseminate in a public forum. But for the most part, you're entitled to protection.
But what if that speech is published, say, by a publisher, and do they retain? If they give you a retainer?
Well, it depends.
They give you an advance. I'm sorry. If they give you an advance, it depends on the agreement that you have.
That's right. That's right. And it's a negotiated situation between a publisher and an author. If you lucky enough to get someone who wants to publish your works, then they present a contract to you, and for the most part, publishers want to retain all the rights, and so to the extent that you are you're in a better bargaining position than most people would be, then you can negotiate just how much you're willing to give up in the way of rights to the publisher, or you may be able to retain all of the rights in your particular work. So it just depends on the negotiating strength of the various parties involved.
Because oftentimes people say, well, I've got these one or two poems and I want to get them copyrighted. And I say to them, well, it would be probably better if you get a collection and copyright them under one title. Because if you do each individual one, it's going to cost like $20. It's more expensive.
Which you just brought up are several different things here. First of all, you've got to determine whether or not the work is copyrightable. And there's a category, what we call insignificant works of authorship, that do not get copyright protection. That could be ideas or facts. You can have ideas in your head all day long, all year long. If you don't pull those ideas out of your head and compose a poem or a song, and what they call transfix the expression, your idea, onto some form, some tangible form, then you can't get protection for that.
So in other words, you can't copyright an idea.
You cannot copyright an idea. You cannot trademark an idea, nor can you patent an idea. It has to be pulled out of your head and, again, transfixed on some tangible thing, be it paper or phone. Well, absolutely. I mean, again, if it's significant enough, and the Copyright Office will let you know whether or not something is significant enough to warrant copyright protection. But